Welcome to Your Next Best Chapter, a Central New Jersey divorce and family law podcast.
Welcome to Your Next Best Chapter, a Central New Jersey divorce and family law podcast with Laura M. Orsi. Laura is a highly respected divorce family law attorney based in Red Bank, New Jersey, with more than 30 years of experience helping individuals and families navigate divorce, custody, alimony, and other complex family law matters. I'm Leanne Lyon, and today's episode, we are talking about equitable distribution. We will dive into how New Jersey courts define fair rather than equal when dividing assets and debts, covering everything from the marital home and pensions to handling hidden liabilities. Hello, Laura. It's nice to see you.
Hello, how are you?
Wonderful. So, Laura, let's start with this. Many people walk into their first consultation thinking that equitable is just a fancy legal word for equal or 50-50. Why is that assumption one of the biggest and potentially most expensive misunderstandings a person can have in a New Jersey divorce?
So in New Jersey, the family courts are courts of equity, and so judges and our statute basically has us look at different factors when we decide how assets are going to be divided in a divorce. And so in some cases, it's pretty clear that the distribution is 50-50, but in other cases, there may be certain assets that were owned by someone before the marriage, or there may be financial and non-financial contributions that people made to various assets. And then also there may be assets that were acquired by gift or inheritance. And and then certain businesses are not divided purely 50-50. So it is a court of equity, and the judges tend to look at various factors in what we call the equitable distribution statute to decide how the assets would be divided and, whether they're 50-50, whether they're, not 50-50. So, there is nothing that says everything is divided exactly 50-50. So it is all subjective in a certain respect.
Okay. Well, I know you've also mentioned previously that assets may be part of the marital estate until the divorce is actually finalized. Does the clock for accumulating shared assets stop the day somebody moves out or on the day that they file the complaint?
So when parties separate and they might be living separately, they are still part of a marital unit. And so even though they might have separate bank accounts and they may not really be living together and part of that joint union together, they're technically still married. So really, until that complaint for divorce is filed, both parties are, acquiring assets that the other might be acquiring just in their own name. That is still considered a marital asset. When we are analyzing all of the assets and how they were acquired, that might be a factor that's looked into, but you're not really protected, I would say, that your spouse does not have an interest in something just by virtue of being separated. Because everyone would say they were separated then, but you're not really protected until that complaint for divorce is filed.
Okay. Well, we also know that New Jersey is not a community property state. So how does this distinction provide more flexibility or maybe even more complexity for your clients?
So in community property states, and again, I don't practice in a state that has the community property laws, but it's my understanding that everything is purely 50-50. New Jersey, I would say, is more subjective and more fact-based because we will look into, like if a business was owned by someone before the marriage, that will be a fact that will be considered in allocating a business. Or if someone had a 401k plan that was acquired before the marriage, that portion of the 401k plan can be viewed as being not part of the marital estate. So I would say it's more fact specific and more subjective in a sense. But, so that could be hurtful to someone who thinks, oh, well, we're married and everything we've done together is part of the marital estate. So it could hurt someone that way if they just assume that everything is marital. Um, but again, it's very fact specific.
Excellent. Well, for many people in central Jersey, the home is the biggest asset. What happens if one spouse wants to stay for the kids, but the other needs their share of the equity to start their own next best chapter?
So, in many cases, because homes in New Jersey are usually people's hugest asset and the real estate market is very high, I would say, most people cannot keep the marital home. They need to either, be bought out by the other spouse or they need to sell the home. So, if one person wants to buy out the home from the other spouse, if the parties agree, sometimes people will say, well, you know what? We think this is going to continue to appreciate. So I'll be your partner and we'll continue to own this home jointly. But in many situations, the other spouse wants to be bought out and they want cash so that they can buy a home for themselves. Sometimes people will say it really again is fact specific. If, say, their children are juniors in high school and they have one more year and they want to keep their child in the school system and they can't buy another home in that town, they might say, you know what, we'll wait until John is March of his senior year of high school, and then we will put the house on the market at that time. So the people will continue to basically be partners in that home and then put the home on the market when their child is spring of their senior year of high school. In other situations where the children are really young, maybe they're in kindergarten or first grade, I think that's a tougher argument to convince your spouse, let me stay here for the next, until our child graduates from high school. That might be a tougher sell, I would think. But it can be difficult for if one spouse has not been working, because usually when you want to keep the home and you need to buy out the other party, you are going to need to also refinance that home. So you're going to need to qualify for a mortgage and you're going to have to show your income. You're going to have to show what kind of alimony you're receiving, any child support you're receiving. We do work with specific people who are called divorce lenders, and they usually help our clients if they would like to stay in a home. However, also right now, a lot of people have really good mortgage rates and people want to keep those mortgage rates. Sometimes we are able to do what's called an assumption, but again, you have to be able to qualify for that. So you have to show that you have the proper income, from your job, from possibly alimony, child support. And then you may also have to even get like let's say you definitely don't have that income to qualify. You may have to ask another family member, perhaps a parent or a brother or sister, if they would co-sign on that loan with you. So it can be difficult for people who, don't have a really high income to qualify to buy out the other person and then also get that new mortgage in their own name. Sometimes what we also can do is we can look at the whole marital estate and see if there's other assets that maybe you might give up your right to certain assets in order to keep more of the home. So again, it's very fact specific. And one thing I have to make clear is that the parties have to agree to all these terms. So it's not just one person saying, I want to do this. The other spouse has to say, okay, I agree. Or, the other spouse may just take the position, look, I don't want you living in the house and I want it sold. And, those can be contentious issues. And usually the court isn't as creative as we can be as attorneys in coming up with different scenarios. So if you go to court, the court is most likely going to say the house has to be sold. But if you work with creative attorneys and you're open-minded as clients, we can come up with some creative solutions.
Excellent. I have a quick question about that. You said if you have say a junior in high school and they do agree that they're going to hang on to it, say that till the spring of his senior year, does the divorce then have to be finalized later, or can that just be agreed upon? The divorce can happen and that's part of the agreement, or how does that work?
We would usually have that written in the agreement that this is what is going to happen, that, the house would, when their child is March or so of their senior year, we'll select a realtor and the home will be listed. And, usually we set forth that whole scenario in the agreement.
Okay. And so the divorce can be finalized in advance of that then.
Yes, yes,
Excellent.
exactly.
Well, you've noted that separation doesn't stop retirement assets from growing. So, how do you handle the division of long term assets like 401ks or New Jersey state pensions?
So, usually in most cases, what is acquired between the date of the marriage until the date of the filing of the complaint for divorce is considered a marital asset. So if one person is working as a teacher with the state of New Jersey and they're acquiring a pension during that time, the portion of the pension that was acquired from the date of the marriage until the date of the complaint would be considered marital. Also, if you work for, let's say, AT&T and you have a 401k plan there, whatever was acquired from the date of the marriage until the date of the complaint of divorce is also considered your marital 401k. So normally what is required is that once the parties are divorced, and again, the agreement will talk about all this, the retirement assets are divided by what's called, in most cases, a qualified domestic relations order. And the nickname for that is Quadro. And so we actually usually hire an actuary who prepares that qualified domestic relations order. And all of these things can only be done once the parties are divorced. You need to be divorced in order for there to be no tax consequences of transferring these retirement assets from one spouse to another. And it can be a lengthy process because the expert prepares this document, this qualified domestic relations order. Then they usually send it to the particular either the company that runs the pension. It could be the state of New Jersey, or in this case, AT&T. That company will then have to approve this qualified domestic relations order. Then it comes back to the attorneys. The attorneys, everyone signs it then. Then we have to submit it to the court, and the judge has to sign it. Then we have to get it returned to us again. And then we have to send it to either the state of New Jersey for the pension or the company for the 401k. And then finally, after that, the monies are released or the interest in the pension is established for the other spouse. It can be quite a lengthy process. So in a lot of cases, we try to limit the amount of qualified domestic relations orders that we do if we can. But in some cases, the parties don't want to agree to that. And so we just have to have all of these different court orders dividing these assets. So
It sounds like something I would not want to have to navigate on my own.
it can be quite difficult.
Right. Well, many of your clients are entrepreneurs. So, how do you value and divide a business without destroying the livelihood that it provides?
So usually when there is a business, we will hire, I mean, depending on the type of business. If someone has a small business where on the weekends they do, let's say they do paint jobs, it's not significant. It's in addition to maybe a full-time job that they have. The parties will have to make a decision whether they want to hire an expert who is usually like a forensic accountant to evaluate that business. They kind of have to see whether they think it's worth it. If the business only makes $2,000 a year, it may not be worth hiring an expert for $10,000 or $15,000 to evaluate your business. If this is really like a full-time venture for your spouse and it is a significant business, then it is definitely going to be worth hiring this expert to evaluate the business. And we work with these different forensic accountants. They usually review income taxes and general ledgers of the business. They look at how much people are paid and if the pay that the executive is receiving from their own business is comparable to what they would receive if they worked for a similar business where they were just a W-2 employee. They also look at whether they were receiving any kind of employment benefits, such as their auto being paid, maybe a gas card, cell phones, or like their Easy Pass, or any other benefits that they were receiving from this business. And then those benefits are basically like calculated back to them as almost like it was income. And so it can be a complicated and lengthy and expensive process. And usually the experts will then prepare a report or a draft report, and we then usually use that in trying to negotiate a settlement, or if need be, if there is a trial or something like that, then the expert will have to come and testify. But all these additional steps that are required of the expert are going to be, you're going to be paying for that. If they come to testify for a trial, you're going to be paying for their time and things like that. So it can be quite expensive, but usually the expert is the one creating a report for us as to what the evaluation of the business is and how much the business is worth. And then they may make recommendations as to what interest in the business they believe the other spouse is entitled to. And some factors that might come into play with that would be whether that spouse was involved with the business. I mean, if it was a joint business where the two people were working at it every day together, that is going to be different than a business where one spouse really had no involvement at all. Also, if maybe the business was owned by a party before they got married, those are factors that are going to come into play as to what the marital value of this business is. Or if like a parent gave the business to the person, all of those things are going to come into play.
You already alluded to this a little bit, but I know that you're a seasoned mediator. So, where do couples fare better in general, through a negotiated settlement or by letting a judge decide?
Usually most people fare better when they're part of the negotiation process. And I don't really know that it's who I can give credit to as a source of this, but it's just known in the matrimonial world that agreed upon settlements are much better than when someone in a black robe tells you what you're going to be doing. So, and people who are involved in the process, they usually, know about their children the best and, what their kids' needs are and how they're going to make those decisions with respect to the assets. Again, if the people can kind of agree, like in the situation where someone has a child who's a junior in high school and needs to stay in that marital home for one more year so they can stay in the school system.
Yep.
If the parents are able to agree to that, that's so much better than, having a person in a black robe say the house is going to be sold, put the house on the market within 30 days, and then you'll divide the proceeds. Because then you might have a situation where the parties actually have to pay tuition to a particular town so that their child can stay in that school system for one more year, or they may have to change schools for their senior year. So the parents are always, and the couple is always the better individual to make a decision versus someone who does not know your family and does not know your particulars.
That's what I would expect. And thank you for sharing that so much. Well, that is it for today's episode of Your Next Best Chapter, a Central New Jersey divorce and family law podcast. If you'd like to learn more about Laura D'Orsi and her family law practice, you can visit lauradiorsilaw.com. There you'll find helpful information about divorce, custody, and other family law matters in New Jersey. Thank you for listening, and remember to subscribe, leave a review, and share the show with anyone who may be navigating this process and looking for clear, steady guidance. Thank you, Laura.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.